The next case that comes before the court this morning is 1011 East Aurora Road LLC versus Board of Zoning and Building Code Appeals et al. Are all parties here?
We
that
are.
We're expecting on this case. Thank you. Do you mind starting a couple minutes early?
That's fine with appellant, Your Honor.
Fine, this one too.
Thank you both. Each party will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If the appellant wishes to reserve any time, please let me know when you get started. I'm keeping track of the clock. You can also reference it on the wall over there. Please don't use the names of any victims or minors. I don't think that it's relevant to this case, but the reason why we always like to mention it is because these arguments are being recorded and the oral argument will be posted on the court's YouTube channel. We are Bridget Weaves. We are ready to proceed when you are. Would you like to reserve any time for rebuttal, counsel?
Your Honor, I'd like to reserve 5 minutes.
Thank you.
Thank you, Your Honors. Mark Cadetti on behalf of the City of Macedonia, Ohio, and the City of Macedonia Board of Zoning and Building Code Appeals. We're requesting that the court reverse the trial court's determination that the BZA acted improperly in this matter. As the court's aware, this primarily involves a parking setback variance. The city's code requires a minimum 20-foot parking setback from the right-of-way. And kind of unusual, but if I could, this may help the court. Let's say the top of the podium here is State Route 82, runs east and west just like it's set up here. This is the current building on the property. So the frontage, so to speak, with State Route 82 currently has no entrances or exits. There is a current entrance exit on what is the east portion of the property, east side of the property, with parking currently existing along that east side of the property also existing in what you could call the back or the side of the property. No parking over here. What appellant is, or what appellee is proposing to do is essentially take the existing building and slap on an addition over here. The appellee is attempting to say we need the access parking off the frontage, which is really not the front of the building right now because there's no entrance, but along State Route 82 as a result of that addition. They say nobody's going to walk 200 feet to get to the entrance. Well, right now there is no entrance down here. There's already the entrance to the side with existing parking. So really what's happening in this case is the appellee is creating the basis for the variance. Currently there is existing reasonable use. The property is currently rented out 2/3, so they have a tenant. The important thing here is they're looking to make the highest and best use of the property. They're not looking to make reasonable use because they're already doing that. The law in Ohio is not that the property owner can do whatever it wants, and if one of the code sections gets in the way, they all of a sudden can get a variance. It just doesn't work like that. So one of the other major issues here is that the trial court created its own evidence. If you look at the record, there's nothing in the record that actually supports the basis for the variance request. There's vague allegations that aren't supported by a study. There's nothing in the record where the property owner submitted, hey, we've gone out, we've advertised, these tenants said that they would come in and rent this property if there were additional parking. There's nothing of that sort in the record. They basically came into the BZA and said, you know what, we need additional parking here because we're going to put in this addition and nobody's going to walk the 200 feet to this new front door. In addition to that, a major issue was they don't know what the future use would be for that addition. They don't know what the future use would be for the remaining 1/3 of the building, which, by the way, the existing tenant has the ability to rent out additional space in the existing portion. So the BZA was unable to analyze the variance request in light of the intended use, because there is no intended use yet, which is another issue here.
Well, there's an intended use to the extent they want to enclose this, make a future business in that area, but they don't know what the business is going to be yet.
Yes,
So
sir.
you have some, so that's what their use is, and they speculate that they're going to need more parking.
Correct.
Is that fair to say that was the testimony at the Board of Zoning Appeals?
So that was the property owner's position at the BZA. The issue with that is the predecessor use was a Huntington bank. The building was obviously designed for use as a bank. It has drive-through windows. The minimum here is 33 parking spaces. When the bank was constructed, they designed it in a little bit of an overkill fashion. There's 45 spaces currently. So there, even with the addition, and this is how the BZA analyzed it, 33 spaces is the minimum. They already well exceed that. So this isn't a situation where the variance is required to meet the minimum parking standard. If that answers your question, Your Honor.
Well, it did part, thank you. I have a question about the, your argument in your brief that they, in essence, you say created evidence of the trial court. One thing that stuck to me was you're saying they used this aerial photo that was not part of the record.
Correct, yeah, in the footnote of the judge's decision, she references approximately 5 or 6 parcels. I actually went back, because we didn't have an opportunity to do this, obviously, at the BZA level, because it didn't come up until the trial court acting on appeal, but no variances were granted for any of those properties.
And we can't consider that.
Yeah, and
Just like you're
Right.
arguing that she couldn't consider it. So with that though, was the aerial photo introduced into evidence at the BZA?
it was not. No, nothing of that nature.
Was there testimony regarding that fact? In other words, did some folks at Board of Zoning hearing say, hey, Gordon Food Service is next door, and this is what their parking looks like, and this business down the road, this is what their parking looks like, and gee whiz, they're all close to 82, so why can't we be close?
There was certainly discussion of GFS at the BZA hearing. There was no aerial showing a broad spectrum of the area like the Court of Common Pleas looked at here.
Was that
It's
introduced
just
by
not.
either party in this case? Do
No,
you know?
no, sir.
Has not attached any brief or anything?
No, sir. So there was discussion about GFS. One of the issues with the trial court's ruling is she uses the GFS for some of the Duncan factors and looks at it and says, well, there's a substantial compliance here. It doesn't negatively impact the surrounding areas because GFS was granted a variance. The rule in Ohio is that if your neighbor gets a variance, you automatically get it too. GFS is a different type of facility. This was discussed at the BZA. GFS is much larger. Additional parking was needed for GFS. That's not the case with this lot. This lot, like I said, already has more than sufficient parking. And in fact, if you add additional parking up along the frontage with State Route 82, it's gonna really increase the density there and make it more difficult for police, fire access, and things like that. GFS lot is more open and won't have those issues. It's just a larger project overall.
And was that testified to or discussed at the BZA?
That, yeah, GFS was discussed at length.
Right, but
And
I'm talking about the safety aspects.
I believe it was discussed at the BZA, primarily between the applicant's counsel and the chairman, Mr. Pilato. So it goes on for many
So
years.
there wasn't
in that regard.
testimony introduced, but there was discussion.
Yeah, there was no testimony by police chief or fire chief or anything like that. But the point is, and this is well documented in the record, that it will increase the density, the number, in other words, the number of parking spaces in the parking lot, which will have an obvious impact on the egress ability. The other thing that was talked about at the BZA, GFS is neighboring essentially, and they have a ingress point to come out of the parking lot and then on State Route 82. A equivalent egress point driveway mirrors it on the other side on this property that we're talking about here. By adding additional spaces here, it's going to increase the traffic here, which could then create backlogs that obviously have impacts on State Route 82. It's another consideration here why increasing the density wasn't supported by the evidence presented to the BZA.
know there was, obviously the whole point is it's like, a little less than 10 feet that they were requesting at the variance.
9 feet.
I can't remember now, did anybody talk about how many parking spaces that would be?
So that actually varied. If you go back and look at the transcript, the applicant property owner first said 17 spaces plus a handicap space, 18 total. Then later on in the testimonies, we're only asking for 14 spaces. In reality, it was just the variance request. They did go to the planning commission who reviewed the proposed plan, but the evidence presented to the BZA was 18 or 14. But they were only requesting the variance, essentially, that the BZA didn't put an actual number on it. So the evidence that was actually presented, like I said, shows that the property is generating a reasonable return, which is the important analysis for purposes of should a variance request, an area variance request be granted here. It's the proposed addition that's creating the need, not the existing conditions. The case law always focuses on what's the existing conditions and is there a need based on those existing conditions.
And counsel, you're just now reaching into that 5 minutes for rebuttal, you can continue or reserve it.
So I'll summarize real quickly here. The appellee knew of the conditions before purchasing the property. There's already sufficient parking and there's already a tenant on the property, so clearly reasonable use is being made. There's no evidence in the record supporting the need for additional parking. If you go back and look, it's just not there. Like I said, there's no experts, there's no studies, surveys, nothing providing support for their request. And well, I won't go into that since we've already discussed that there's really no basis for the evidence brought in by the trial court, which was relied on at numerous points in the trial court's opinion in reversing the BZA. So I ask that the court grant the assignments of error and reverse the trial court in this case. Thank you.
Thank you, counsel. You'll have 4 minutes for rebuttal.
May it please the court, my name is Jeff Snell. I represent the appellee in this case, 1011 East Aurora Road, LLC. I want to give you a little history because it's going to help answer some of those questions that you also had from the bench. In 2017, my client acquired this property. It was a Huntington Bank built in 2005. The bank has a large banking area, office area with a side door and side parking. It's designed primarily for drive-through. There are 4 drive-throughs under a roof that is absolutely beautiful and finished and meets the standards of the building, all that good stuff. But there are these drive-through lanes that have posts in them and concrete to the west side of the property. My client had proposed enclosing that area. He went to the Planning Commission of the City of Macedonia in 2018, and you asked about, there was some discussion about the plan, and in the actual record below, on page 26, there's an actual diagram that we presented to the Board of Zoning Appeals. It was approved in 2018 by the City of Macedonia Planning Commission with no variance. It was completely approved.
And is that in the record?
It is, absolutely, Your Honor. And it was testified to, and it was affirmed because the chief building inspector was there, the zoning inspector was there, the law director through all these proceedings. So yes, he had an absolute approval. The city, he then did not immediately build the addition and fill in the walls. So he went back to get his permit in 2021, just over 2 years after it had, quote, expired. The city said, I'm sorry, your plan has expired, you've got to go back to the Planning Commission. He went back to the Planning Commission. He went back with the same architect, the exact same plan. The Planning Commission completely approved his plan. But at that time, the city said, there were no changes in zoning, by the way. In the B2 district, you must seek an appeal. You must go get a variance for the front yard setback. Nothing else, the front yard setback. It's not a parking setback, it's the front yard setback. Front yard has to be 20 feet off the sidewalk. So my client then went to the BZA in August of 2021, took his architect, I wasn't there, and he went and proceeded with them, and they said, well, you know, aren't there other ideas, aren't there other options? And they said, if we vote on this today, you'll never be able to hear this again if we vote against you for another year. So maybe you should table this matter
and then come back and see if there's any other options here with your architect. And he agreed to table it. He then came to see me, and we reviewed the plans and reviewed the record. At that time, in 2021, he was seeking a 9.9-foot 4-inch variance for that. His architect had reviewed those plans. We listened to the tape and the obvious options that these board members had pointed out. We reviewed those options. And in December of 2021, in the record, I wrote a 3-page letter that documented the Duncan standards and why the variance should be granted. And that's included on pages 9, 10, 11, 12 of the record. But page 12 is probably the most important. It's the aerial view that the city said was speculative and the judge was off the reservation looking at. That's actually in the record on page 12. And in that...
Is that in the record, or was that actually introduced as part of the record?
Your Honor, what happened is we talked about it. I presented it to the board 2 months before the hearing. I mailed it to the board, and the board received that document. And at the hearing, we talked about that drawing, the same drawing of my letter. Was it introduced as an exhibit? The answer is no, but it was the same. It's the record that the city produced in the appeal. It's contained on pages 9, 10, 11, 12. I presume, just like the Board of Appeals, the judge read it as part of the record, right? Because it was part of the record. It talked about the Duncan factors, it talked about the parcel numbers, and then if you read the record from pages 13 on, we talk about the actual parcels and how, when you look across the character of the neighborhood, they all had violations of the front yard setback. And what I said was, I found in the record that Gordon Food Service had a variance in the front yard and built parking, and they received that variance in 2015 before they even built the building. They got a variance from their front yard setback before they even had a building. Well, you have to meet practical difficulties. Well, the practical difficulties is they wanted to build a big building, and they wanted to have more, the ability to park closer to the front of the building, so they had to have a variance. But it wasn't really like my client. My client had a building that's in the middle of the property that can't be moved. This whole idea that we were slapping up a building is ridiculous. What happened is there was an enclosure where, there's a roof where the drive-through lanes are. It's all finished. He wanted to build walls in there, and the planning commission said twice it was appropriate. It met all city standards. It met the Western Reserve theme, the brick, all the requirements of the city. And so we went forward and presented that to the BZA. And the BZA, this is most important, the BZA spent a lot of time talking about this, but there were only 4 members present at the BZA. And so when we got to the end, the vote was 2 for the variance and 2 against the variance. In other words, an even split. And at that moment, the law director ruled that it failed, right? Because we didn't have the 5th member. So at that moment, I could have run to the Common Pleas Court and filed an appeal. But what we did on March 7th is we filed a motion for reconsideration. We said to the board, we would like to come to the next meeting, and we would like the 5th member to be able to review this matter. And that board, the 2 that were against the issue in the first place, came to that second meeting. There was no discussion. We were not permitted to speak. They made a motion to reconsider. The 2 that voted against it voted against the reconsideration. The person who was not there at the original meeting voted to reconsider, and so did the 1 member who had been at the meeting who voted in favor. That 5th member, the other member, wasn't there. So it failed yet again. I gave them an opportunity to hear the whole case, but they declined to do that. This whole case turns a bit on the Duncan factors, right? Is there practical difficulties? And the board spent a lot of time talking about it, and I want to talk about that too. Duncan has 7 factors, none of which weigh heavier than any other factor, right? You look at them as a totality. The review that you're conducting today is abuse of discretion. Did the trial court abuse its discretion when she determined that their decision was unreasonable and unsupported by a preponderance of substantial, reliable, and probative evidence in the record? For you to reach that standard, you gotta either figure out, like he's arguing, she was looking at things that weren't there. Well, they were absolutely there in the record. This aerial was there. Those parcel numbers, they were contained in my letter. In the record, I said, I can read all these parcel numbers to you of the other properties in the neighborhood on that aerial view that violate the same front setback. And they either got grandfathered in or they got a variance. And then he now says, for the city, I finally went back and looked at this and oh, nobody has a variance. That isn't in the record, right? That isn't in the record. I could only find one variance next door, and I could find evidence all the way down the road
Well,
that
it's
they
not in the
violate.
record. See, this is the thing with both of you. We
Well,
can
I'll be
only
careful.
consider what's in the record.
I understand.
And it's the same thing with the trial court. Would you agree to that anyway? The trial court can only
Yeah.
consider what's in the record.
Absolutely, and Your Honor, I can call those sites in the record as we go through here. It was in the record that, that there were various properties along 82 that violated the 20-foot setback that the city required.
And that was in the record by the photograph you produced, or how?
The photograph, and we actually talked about it. We pointed out the parcels and we talked about those parcels in the record.
By parcel numbers or by name, like
By
Gordon?
name. By name. One we talked about as an owner. One we talked about, the others we talked about as, you know, this property adjoining. But you can read that in the record and see that. The judge read the entire record and read all the written records that had been produced. I actually said during the hearing, I can read all these parcel numbers, right? But it wasn't necessary. Everybody had read that. They had it for 2 months. We knew what we were talking about.
Well, are you advocating for the court to be able to consider your arguments and your briefs as evidence? Before the
Today?
Before the BZA?
Well, there's certainly arguments. It's just like the application, Your Honor, right? It's part of the application of the applicant seeking the variance. I had produced the records of why the variance should be given. Let me go through those Duncan factors. I think that'll help tie this together. The first is, will the property yield a reasonable return, or can there be a beneficial use of the property without the variance? The judge acknowledged, yes, we have 2/3 of the building rented. Whether the variance is substantial, that's number 2, or, and number 3, whether the essential character of the neighborhood would be substantially altered, or whether adjoining properties would suffer substantial detriment as a result of the variance. All the adjoining properties got notice, it's in the record. Nobody came in and objected. Nobody from the public objected to this variance. And then we talked about Gordon. Gordon had a 7-foot front yard variance right next door. We were proposing the same fencing. This isn't a property that sits above the pavement of 82, it sits below. So Gordon had actually cut out an area and built a retaining wall and put a fence and landscaping. It's all in our plan too. And then the parking, the head-in parking would sit there. There was no dispute on the number of parking spaces. There were 18 spaces, 14 of which were in the setback area, 4 of which were up closer to the building. There were a total of 18. There was an ongoing, there's another issue here that's not really in the appeal at all, but there was an issue as to whether you could build more parking spaces than the parking spaces that are there. It's important to understand this property. When you drive around the property, you drive into these drive-throughs, and then there's just a single driveway going out. One of the factors that was brought up was whether the property, under Duncan, whether the property owner's predicament could be obviated through some other method or variance, and we talked about those. So on page, on transcript 16, we talked about eliminate the 2 entrances on Alexandria Way, close one of those, and then maybe you could put more parking over there. And we said you can't do that because the fire code requires 2 entrances and 2 exits. You can't close the entrance. We'll move the entrance. That was another idea. Transcript 17, move the entrance, move that driveway. You can't move the driveway because the building is there. And you have to align with the Gordon Food entrances and exits so people can get back and forth. The other idea was move parking to the west side of the property. Put in head-in parking or parallel parking. We only have 32 feet to deal with. We needed to have, we would only have 12 feet right next to the building for a lane, and we violate the fire code because we have to get back and forth around, that's all in the record. So we eliminated all these options that had been discussed. We pointed out that Gordon also had a side yard variance. Gordon was supposed to have 25 feet off their side yard, they only had 10. We discussed how in the neighborhood that it was consistent to have this. The last Duncan factor to look at is whether the spirit and intent of the zoning requirement would be observed and substantial justice done by the granting of the variance. There are truly practical difficulties here for my client. That's why 2 of the 4 members voted in favor of my client. The practical difficulties are we can't move the building. There are no other options. We can't rent a space for commercial use where you have to walk 200 feet from the rear of the building to the front of the building to get in the front door. There's nowhere to park in front of the building. We can't move the building. We can't, we have to try to accommodate that. It's interesting.
Just a question about the record.
Sure.
We'll run out of time.
Yep.
Was it argued at the trial court that this photograph isn't part of the record before the Board of Zoning Appeals?
No, Your Honor, what we did is we did it all by brief, and there was no reference about that aerial photograph. He's gonna argue, well, I didn't know she was gonna look at the aerial photograph, but for him to say that it was false evidence or she looked outside the record, it's right in the record, right? The record is not just the transcript. The record is the entire record, the application and all the correspondence.
Did you refer to the aerial photograph in your briefing below, do you recall?
I do
If
not.
you recall.
I don't recall if I did recall referring to the neighboring properties that are all depicted in the only area photograph that we had, the one that we discussed during the hearing.
And counsel, I'm gonna need you to wrap up as you are over time.
No problem. Thank you, Your Honor. I don't think that the court abused its discretion in finding the denial to be unreasonable and unsupported by a preponderance of the evidence, and I think you need to affirm the decision of the Common Pleas Court and agree with the 2 members of the Board of Appeals that also approved this. Thank you for your time.
Thank you, counsel.
So just to be clear about the trial court's reference to the aerial view, it's just that. The trial court judge said the aerial view of the property. The judge didn't say this plat submitted to the BZA or discussed at the BZA. It's just a general reference to the aerial view. I don't know if the judge just pulled up Google Maps and looked at it, but it's clear there's nothing in the record that shows these permanent parcel numbers obtained these variances. In fact, there's nothing in the record, if you go back and look, where it actually has introduced and has as an exhibit or something else, a variance was granted for parcel X, Y, or Z.
But the aerial view that was included in the briefing at the BZA did include the parcel numbers.
There's nothing referencing a variance
I
connected to
didn't
a
ask
parcel.
you that.
Yeah, there's a general
Parcel
aerial
numbers.
view that was
Yes.
submitted, correct.
Yes, because I understand there's maybe a difference, but
Correct.
I just want to know if the parcel numbers were included, because you had said something about maybe she Googled it, but she wouldn't have to Google it if it was right there.
Perhaps, I don't know that, and that's one of the issues. It really wasn't discussed at the trial court, and I don't know what the judge was looking at. It could have been that aerial, I do not know. And that's the
If
issue.
you look at that aerial, are you arguing there's any error for her looking at that aerial that was included in the record?
No, the judge can certainly look at anything in the record. The ultimate problem is that was used to say that variances were granted for these other properties. and there's nothing in the record, I know, I'll be careful because this isn't in the record either, what I'm referring to, but there's nothing in the record showing variances granted for any of those properties, and there's actually not even anything in the record of the actual variance granted to GFS. One of the things that your honors mentioned was that, well, is your statements to the BZA evidence to Mr. Snell? It's argument. There's no actual evidence supporting this variance request.
Was
And
there actual testimony at the BZA?
there was some limited testimony by the property owner, but it wasn't that other variances were granted with one exception, which is a dermatology location down State Route 8. I think the testimony there from the property owner was, I looked it up, and there were 5 variances granted for that. That was really the only discussion by the property owner
Five
testimony.
variances granted for the dermatologist's office?
Correct. And there was absolutely no discussion as to what the facts or circumstances were there. There weren't any minutes introduced or anything of that nature. So that limits it. So one of the things the owner and Mr. Snell had mentioned, well, these other properties that the judge references are just, if you look at the aerial view, all those other properties violate the 20-foot parking setback. If you look at that variance and what that argument ignores, State Route 82 was widened going back 2005, 2006. You can look at it and see it went from a 2-lane road to a 5-lane road in some places. That was accomplished by ODOT. That included appropriations, quick takes to accomplish the expansion. That resulted in properties being left with less real estate than they normally would have, which is why some of those properties exist, like you see in the aerial that is in the record. Again, no evidence of any other variances granted. There's no evidence that any other property is existing in non-compliance or in violation, I should say, of the code.
And counsel, you have about 10 seconds, so you're gonna wanna wrap it up.
I'll just touch on the last thing. There was reference to the planning commission not requiring a variance back in 2018. There is nothing in the record of that other than Mr. Snell's reference to it to the BZA, no evidence.
Thank you, counsel.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision in due course, which we mail to all parties to this appeal by the clerk of courts. It will also be posted on the Ohio Supreme Court website. Thanks again.
Thank you.